Your Lordship, may I would like to read it.
Please read it.
अभियोजन का प्रकरण संक्षेप में इस प्रकार है कि पीड़िता द्वारा दिनांक 10/11/16 को थाना कानीवाड़ा जिला सिवनी मध्य प्रदेश में इस आशय की शिकायत प्रस्तुत की गई।
इतना बता दीजिए कि आपका इशू क्या है. There are two things which go against you. One is your age. You are major, admittedly major at the time of the incident. आपका डेट ऑफ बर्थ 96 का लिखा है. आपका साथ घटना हुई है मार्च 2016 में. दूसरी चीज ये है डीएनए जो है, आपने बहुत सारे सजेशन दिए क्रॉस में कि वो जो उसका जीजा है उसके साथ डीएनए मैच करेगा. एंड बट डीएनए रिपोर्ट इज positive for the accused who has been acquitted. Now, trial court has recorded a finding that it was apparently a case of consent. You did not reveal this fact that your privacy was violated for long 8 months. When your mother saw some swelling in your legs, then your mother asked, and then you revealed that the prosecutrix is pregnant. Therefore, taking these three circumstances, namely majority of the prosecutrix, apparent consent, reflected from the fact that she did not reveal this fact of violation of privacy for 8 months, and matching of DNA with the appellant being considered as a circumstance of consent, acquittal has been recorded. Now, on what basis you want that this man should be convicted?
Lordship, I would like to refer then by the statement of the prosecutrix. There are some nitty-gritties that I would like to point out.
Please study. Let us come to it directly.
Your Lordship, I will start by paragraph number 3, line 4.
Yes.
घटना दिनांक को दिन में description that is given by which will show that how this incident was
Yes, we
non-consensual.
have gone through that. But the fact of the matter is that for 8 long months she maintained silence. If that incident took place in March 2016, near about Holy Festival, then she could have reported it after 2 days, 3 days, 4 days, even a month, because Supreme Court is very categorical that few days delay will not come in the way of the prosecution. But here the delay is of 8 months.
Your Lordship. Lordship,
Matter was reported in November 2016.
Lordship, allow me to
And
read.
she has also, I will permit you to read. And she has admitted that if mother would not have asked for the reason of swelling in my legs, then I would not have revealed that, yeah, I'm pregnant. This is what prosecutrix has said in her cross-examination.
Yes, Lordship.
She has also admitted, though it's an indirect suggestion, that even her sister got into a relationship with her brother-in-law, and when the people of the village came to know of this fact, then they entered into wedlock. She has also said that if he would have married her, then there would not have been any problem. मैं उसके साथ शादी करके उसके साथ रहने को तैयार थी.
Your Lordship, we can see the relationship of the prosecutrix and the accused.
What is the relationship?
The accused is the chacha of the prosecutrix.
Right.
And we can also...
Not real chacha.
Definitely.
Paragraph number 14 of the last examination of the victim.
Your Lordship.
पढ़िएगा प्लीज.
जी. मेरा जीजा संजय का मकान, मेरे जीजा संजय का मकान मेरे मकान के सामने एवं अभियुक्त निकोल के मकान के पीछे है. अभियुक्त निकोल गांव के रिश्ते से मेरा चाचा लगता है.
गांव के रिश्ते से. Emphasis is on गांव के रिश्ते से. There is no blood relationship.
Your Lordship. Your Lordship, for this, I would also like to refer the map, the house of where the house of the... Yes, Your Lordship.
Exhibit?
In the record, it's page number 45, Your Lordship.
We'll see. We'll go through this. Spot में नहीं spot में. Exhibit क्या है उसका?
Exhibit, Your Lordship.
चल कोई बात नहीं, हम देख लेंगे.
Exhibit.
P4
is...
जी क्या बता रहे हैं इसमें?
Your Lordship, ki the house of the prosecutrix and the of the accused are not far, but they are just adjacent to each other.
Right.
So this shows the access of the accused to the prosecutrix. Means, as we can see in the FIR or the prosecution story, the accused का आना जाना था वहाँ पे prosecutrix के घर में, और
वो जानते थे एक दूसरे को.
Yes, Your Lordship.
गांव में आना जाना.
ठीक है. और there is a social study also that अधिकतर privacy violation के cases जान पहचान वालों में होते हैं. आपकी hypothesis क्या है? एक hypothesis ऐसा बताइए, एक submission ऐसा बताइए जिससे we are persuaded to change our mind and record conviction against this accused person.
Yes, Lordship. Your Lordship, my first submission on this point will be, which I will be elaborated further, that in this examination of the prosecutrix, the chief or the cross, nowhere it has been rebutted by the defense that such incidents was never occurred. It was never shown that the accused was not there at the place of incident or never
Accused is
went.
there, his presence is proved by DNA report. आपका ये suggestion तो ठीक है, बिल्कुल ठीक है ये.
Your Lordship. The act that has been done was under a fear and सर मार डालने की धमकी दी थी, इसीलिए प्रोसिक्यूट्रिक्स ने उसको इतने समय तक द रीजन फॉर द डिले इन द एफआईआर.
अच्छा,
इस्माइल.
चलिए कॉपी तो दीजिए और बुक का. जी. और क्या पॉइंट है तीसरा? थ्रेट एक हो गया, एक इजी एक्सेस हो गया.
यस लॉर्डशिप.
दूसरा
So the consent part that lordships are referring, the consent that is depicted is because of the, as we can also see from the section 375, the consent is taken by डरा धमका की lordship.
हाँ हाँ वो थ्रेट आ गया ना.
Yes, lordship.
और बताइए.
The statement of the prosecutrix has been also been corroborated by her mother and her sister, which are PW2 and PW3.
ठीक है.
And I will also elaborate on that point that कि जब उसने FIR की, that the month in November जब उसने FIR की, तो उसने FIR की जब victim ऐसी डरी हुई थी कि उसके कंडक्ट के बारे में जब उसकी माँ को पता लगा, तो that was the turning point जब उसने उसकी माँ ने पूछा that victim is your lordship a poor and illiterate girl who is not aware of the thing. Therefore, when the mother of the prosecutrix has asked about such an incident, then the prosecutrix has told about her, then they went
चलिए
to the doctor.
लिखिएगा. मिस सोनल पटेल.
Lordship, one more point.
हाँ हाँ बताइए.
Lordship, may kindly refer to the paragraph 6 of the prosecutrix statement.
जी पैराग्राफ 6.
PW.
Prosecutor PW1.
यस.
The prosecutor states that इसके बाद मैंने अभियुक्त के माता पिता को बताया कि मैं गर्भ से हूँ, तो अभियुक्त के माता पिता ने कहा कि कुछ नहीं होता, 5-6 हजार रुपए ले लो और इलाज करा लो. इसके बाद दैट मैं कान्हावाड़ी थाना गई और मैंने रिपोर्ट कराई, लेख कराई.
ठीक.
That this statement by the parents of the accused is also an offense. Stating her that
इसलिए आपको प्राइवेट कंप्लेंट लगाना चाहिए थी या चार्ज की स्टेज पे आपको बोलना चाहिए था.
319 में दवाई से बताते हैं.
हाँ आज क्या होगा. चलिए देखिएगा. मिस सोनल पटेल, आपका यही शुभ नाम है ना? सोनल पटेल नाम है ना?
lordship.
मिस सोनल पटेल.
Also, I would like to refer some judgments, your lordship.
हाँ दीजिए ना. यस.
The
क्या
judgments,
है गंगा सिंह में क्या है?
sir, it's may kindly refer to paragraph 11 and
11 years.
7.
ठीक है और बताइए.
Lordship, in the next judgment for the delay in lodging the FIR, I would like to refer judgments of Tulsidas Kolkar,
Yeah.
Konalkar,
पैरा नंबर.
paragraph 5.
Yes.
In which it says that the delay per se is not a mitigating circumstances for the accused when the accusation of rape are involved. As the factual scenario, this is for this case, delay in lodging the in the FIR cannot be used as a ritualistic formula.
ठीक है तो चलिए.
And second, your lordship, for the delay part, Satpal Singh is
Yes.
also judgment I would like to refer.
पैरा.
Paragraph 10. in this, the lordship, there was a delay of 4 months in this case. So it has been, if the delay has been, delay in lodging the FIR has been satisfactorily explained, then the delay in lodging the FIR in sexual offences has to be considered with a different yardstick.
ठीक है.
And your lordship, the last one is of the Allahabad High Court, of the division bench of the Mukhtar Ahmed versus State of UP.
Yes. You are referring to paragraph.
Uh, Paragraph 20. Actually, I gave both the copies. So
ये लीजिए कॉपी. ले लीजिए मैडम. कौन सा पैराग्राफ है? अच्छा, मुख्तार अहमद के केस फैक्ट्स अलग हैं.
Lord, in this also, it was that the
उसमें
offences
मुख्तार अहमद के
are-
फैक्ट्स ये हैं कि अंडर थ्रेट एंड कोएर्जन दे कुड नॉट लॉज एफआईआर.
but I would also refer the judgment that has been cited.
हाँ बताइए.
2 weeks before the date of disclosure.
Paragraph number 52.
ये पैराग्राफ 52. ठीक है, लिखिएगा. चलिए, अपील इज फाइल्ड है ना, लिख लिया था. नहीं, अभी आप नए आए हो. ये उनको जब बीच में मैं लिखा रहा हूँ ना, तो बीच से उठ के क्यों जाते हैं? भेजिए उनको. किसने लिखा था जब मैंने शुरू किया था? हाँ, तो ऐसा थोड़ा ना होता है कि मैंने लिखाना शुरू किया वो घड़ी देख के भाग जाएंगे. इतनी तो बेसिक कर्टसी होना चाहिए. बुलाइए. ये सब चीजें सीआर में रिफ्लेक्ट करूंगा मैं. आप लोगों को इतना बेसिक नहीं है.
I'm also relying on the judgment of Delhi High Court. In this case, my lord, the case which has been referred by appellant.
जब मैंने लिखाना शुरू कर दिया था तो आपको बैठना चाहिए था. नहीं, ये तरीका सही नहीं है. You are referring to which paragraph?
Paragraph number 28, the Tulsidas Kolarkar versus State of Goa, that has been discussed, my lord, and the finding in paragraph number 35
Yes.
of a DNA report.
हाँ बताइएगा.
May I read, my lord?
Yes.
The prosecution also placed reliance on the DNA report Exhibit P9, which established that the child born on the prosecution was biologically fathered by appellant. This fact is not disputed. However, the DNA report
लिखिए.
clearly proves
कहाँ छोड़ा था?
paternity.
वहाँ आगे लिखना शुरू. Appellant submits that appellant is aggrieved of the judgment dated 17/2/2022 passed by learned 4th additional session judge Sydney in ST number 177/2016, whereby learned additional session judge has recorded a finding of acquittal for the accused, respondent herein from charges under section 450, 376(2). ये जज ढ क्या है?
And
ज और ढ देखिएगा क्या आता है. इतना इतना. And 506, ये लीजिए सर. And 506 part 2 IPC. Full stop. Next paragraph. It is submitted that prosecution story in brief is that respondent accused is known to the prosecutrix in the he is her uncle in relation to the village relationship. Full stop. On 26/3/2016 at about 12:05 p.m. respondent had entered the house of the prosecutrix after asking for other housemates. Huh?
H and N.
H and N है वो 376 within bracket H and another bracket N. हाँ, क्या हुआ? He had violated her privacy against her will and violated her privacy under the threat of life. Next paragraph. It is submitted that after 12 days of the first incident, her privacy was again violated when she was alone at home in the afternoon. Full stop. Next paragraph. On 6/11/2016, when her mother of the prosecutrix PW3 had noticed swelling in her swelling on her body and in legs, and she had inquired about such symptoms when she had informed that he does not know. Thereafter, his mother and sister had taken her to Dr. Katre at Sivni, where Dr. Katre had informed that she is pregnant for 8 months. Next paragraph. Thus, it is submitted that conviction, sorry, वो 2N है उसको वो सब 376 2N है बस, ठीक है. Thereafter, report was lodged registering case crime number 387/16 under section 452, 376, 2 and 506 IPC. Full stop. Statements were recorded. Samples were sent for FSL investigation at Sagar. A spot map was prepared. Thereafter, a respondent was arrested and charge sheet was filed. Full stop. Matter was committed to the Sessions Court, where respondent abjured his guilt. Trial was conducted and appellant has been acquitted. The respondent has been acquitted. Next paragraph. It is submitted that evidence that firstly, the incident took place under threat and coercion. Prosecutrix has clearly stated that she was under threat and coercion. Secondly, there was an easy access available to the respondent as his house is in the close vicinity. Full stop. Thirdly, it is pointed out that the relationship between the appellant and the respondent was that of niece and uncle. And fourthly, the statements of the prosecutrix are corroborated by PW3 and PW4, that is mother and sister of the prosecutrix. Next paragraph. It is further submitted 2 and 3. It is further submitted that prosecutrix is poor and illiterate, and thereafter reading para 6 of PW1, it is submitted that when the prosecutrix had approached the parents of the respondent and informed them that she is pregnant, then his parents had said that it does not make any difference and had offered her 5-6,000 rupees for treatment. Thereafter, she had lodged FIR Exhibit P1. Full stop. Next paragraph. It is also reliance is placed on the judgment of Supreme Court in Ganga Singh versus State of Madhya Pradesh 2013 का 7 SCC 278 and relying on para 11 of this judgment, it is submitted that the burden of appellate it is held that prosecutrix is a victim of and not an accomplice in a sex offense, and there is no provision in the Evidence Act requiring corroboration in material particulars of the evidence of the prosecutrix, as is in the case of evidence of accomplice. Full stop. Similarly, reliance is placed on judgment of next para. Supreme Court in Tulsidas Kanolkar versus State of Goa 2003 का 8 SCC 590 and referring to para 5, it is submitted that in any event, within inverted commas, in any event, comma, delay per se is not a mitigating circumstance for the accused when the accusations of rape are involved. Full stop. Delay in lodging the first information report cannot be used as a ritualistic formula for discarding the prosecution case and doubting its authenticity. Full stop. It only puts the court on guard to search for and consider if any explanation has been offered for the delay. Full stop. Once it is offered, comma, the court is to only see whether it is satisfactory or not. Inverted commas close. Next paragraph. Reliance is also placed on the judgment of Supreme Court in Satpal Singh versus State of Haryana 2010 8 SCC 714, wherein referring to para 10, it is submitted that delay in lodging of FIR for 4 months after about 4 months of the commission of offense will not be of much consequence, because if there is ample evidence on record to show that there was some pressure or coercion on the informant not to report the matter in time. Next paragraph. Reliance is also placed on the judgment of Allahabad High Court in Mukhtiar Ahmed versus State of UP. इसका citation है, कानून देख के लिख लीजिएगा, क्या है, निकाल के दे दीजिएगा भाई, इतना. Wherein relying on para 52, it is submitted that Supreme Court has referred to its previous judgment in, Supreme Court, Allahabad High Court has referred to judgment of Supreme Court in Mrityunjay Viswas versus Pranab alias Kutti Viswas and another 2013 ka 12 SCC 796, wherein Supreme Court has held that within inverted commas 28 ... it is well settled in law that the minor discrepancies are not to be given undue emphasis and the evidence is to be considered from the point of view of trustworthiness. Full stop. The test is whether the same inspires confidence in the mind of the court. Full stop. If the evidence is incredible and cannot be accepted by the test of prudence, comma, then it may create a dent in the prosecution version. Full stop. If an omission or discrepancy goes to the root of the matter and ushers in incongruities, comma, the defense can take advantage of such inconsistencies. Full stop. It needs no special emphasis to state that every omission cannot take place of a material omission and, comma, therefore, comma, minor contradictions, comma, inconsistencies or insignificant embellishments do not affect the core of the prosecution case and should not be taken to be a ground to reject the prosecution evidence. Full stop. Thus, it is submitted that it is a fit case to record reversal of the finding of acquittal and conviction should be replaced with acquittal. Next pair. Shri.
Anurag Bhudolia.
Eh?
Anurag Bhudolia.
Anurag Bhudolia, appearing for the respondent in his turn, places reliance on the judgment of High Court of Delhi at New Delhi in CRLA, ये सब number लिख लीजिएगा, decided on 20 March 2025, where he has placed reliance on para 35 of the said judgment, which says that within inverted commas, the prosecution also placed reliance on the DNA report within bracket exhibit PW9 oblique capital A bracket close, comma, which established that the child born to the prosecutrix was biologically fathered by the appellant. Full stop. This fact is not disputed. Full stop. However, comma, the DNA report merely proves paternity. Dash. It does not and cannot, comma, by itself, comma, establish the absence of consent. Full stop. It is trite law that the offense under section 376 of the IPC hinges on the absence of consent. Full stop. Mere proof of sexual relations, comma, even if resulting in pregnancy, comma, is insufficient to prove rape unless it is also shown that the act was non-consensual. Full stop. In fact, comma, the surrounding circumstances render the prosecution's case highly improbable. Full stop, inverted commas, close. Next paragraph. After hearing learned counsel for the parties and going through the record, it is necessary that evidence given by material witnesses by material witnesses as recorded by the trial court be appreciated in the correct perspective. Full stop. In her examination, Chief Prosecutrix PW1 has admitted that her privacy was violated twice. First in March 2016 and secondly somewhere in April 2016. Next, it has also come on record that respondent had threatened her. Full stop. Then in para 5, prosecutrix states that when there was swelling in her legs, then her mother had inquired about it. Then they had taken her to Dr. Kiran Katre at Sivni, where she was reported to be pregnant for 8 months. Next one. Age of the prosecutrix, as is mentioned in the deposition sheet, is 21 years, and this statement was recorded on 28/7/2017. Full stop. She has admitted this fact of being major in para 13 of her cross-examination, where she stated that her date of birth is 14/7/1997. Full stop. Next. She has also stated that date of birth of her child is 18/12/2016. Next para. In para 6 of her examination in chief, prosecutrix has stated that when became pregnant, she had approached parents of the accused who had offered her 5,000-6,000 rupees for treatment. Next para. In para 16, she admitted that she was willing to marry the respondent accused when she came to know of the fact that she was pregnant. Full stop. She has also admitted that accused is residing in close vicinity, and she has also stated that accused is her uncle by relationship amongst the villagers. Full stop. This statement is important in as much as prosecutrix herself has stated that accused is in her relationship by way of relations as are usually accepted in a rural background. Full stop. It is thus apparent that accused is not her real uncle. Full stop. Next one. In para 17, she has stated that after first incident with her, she had carried out all her household work properly. Full stop. She admits that constantly she was carrying out her work properly. Full stop. She also admits that during this period of her pregnancy, for 8 months, she was continuously meeting her parents and relatives and were talking to them. Full stop. She has further stated in para 18 of her cross-examination that if her mother would not have asked her about the swelling in her legs, then she would not have revealed that she was pregnant. Full stop. In para 21, she has stated that it was known to them that accused was not married and he was belonging to their community only. Full stop. Next pair. PW2, mother of the prosecutrix, has admitted that she and her husband were working on a brick kiln. Full stop. About 8 months prior to the date of deposition, she found swelling in the legs of her daughter, and then on inquiry, prosecutrix informed that she does not know the reason for such swelling. Then she was taken to Dr. Kiran, where Dr. Kiran Katre, upon checkup, informed that she was pregnant for 8 months. Next para. When on inquiry, prosecutrix had informed that she was carrying child of Nilok, that is the accused, in her womb. Full stop. In cross-examination, this witness has admitted that her daughter, that is the prosecutrix, had never informed her about pregnancy, and when she had seen swelling on her legs, then she had taken her for checkup with the doctor. Next para. In para 9, this witness admits that after 4 or 5 days of the checkup in the hands of Dr. Katre, report was lodged. Full stop. She has also stated that after medical examination, they had discussed the issue, and when parents of the accused refused to keep their girl, then they lodged report. Full stop. Next question. Full stop. On the contrary, facts of the case reveal that prosecutrix was working normally. She was meeting her relatives in normal course as stated by PW3, and then even on asking of her mother, she did not decide to reveal the true facts. Full stop. Thus, it is evident that she was not under any threat. Full stop. Coupled with this fact, prosecutrix, after declaration of her pregnancy by the doctor, which must have been known to the prosecutrix herself, met the parents of the accused and asked them to marry their son with the prosecutrix. full stop. Thus, if there would have been any threat, then there would not have been any proposal, there could not have been any proposal to meet the parents and propose them to marry the accused, full stop. Thus, theory of threat is not established by the prosecution, and in absence of such theory being established, comma, when court is court examines the offer, examines the explanation offered for delay in FIR, then it is satisfied that there is no proper explanation in regard to delay in lodging of FIR. Next paragraph. In Satpal Singh versus State of Haryana, facts are different. In that case, local panchayat had intervened on the next day of the incident and pressurized the complainant to compromise the case and settle it outside the court. Full stop. However, it has been noted by the Honorable Supreme Court that though FIR was lodged after about 4 months of the commission of offence, and that was done on the instructions of the Superintendent of Police Kurukshetra, but complainant was under pressure of the local panchayat, which wields lot of influence in rural settings in the state of Haryana. Full stop. But in the present case, there appears to be no such element of threat and coercion as sought to be brought out by the appellant. Therefore, facts of the case of Satpal Singh being different are distinguishable. Full stop. Next paragraph. As far as judgment in Mukhtiar Ahmed is concerned, and reliance on the judgment of Supreme Court in Mrityunjay Biswas Supra is concerned, comma, the test which has been laid down by Honorable Supreme Court is that minor discrepancies are not to be given undue emphasis, but the test is whether the same inspires confidence in the mind of the court. Full stop. If the evidence is incredible and cannot be accepted by the test of prudence, then it may create a dent in the prosecution version. Full stop. In the present case, facts obtaining in the case are such that causes dent to the version of the prosecution for not recording the FIR and even not reporting the matter to the close relatives like mother and sister, despite being in constant touch with them for a long period of 8 months. And therefore, consent may or may not be there, but it is true that the element of forceful violation of privacy, as discussed by Delhi High Court in Nathu is concerned, is missing. Full stop. Delhi High Court has rightly held that the trite law, that it is trite law that the offence under section 376 of IPC hinges on the absence of consent. Full stop. Absence of consent, therefore, since could not be established beyond reasonable doubt, comma, it is insufficient to prove rape, and therefore, in present facts and circumstances, comma, when impugned judgment passed by the trial court is tested, it cannot be faulted with. Appeal fails and is dismissed. Questions?